Welcome everybody to D&B's 5-minute briefings. I'm Neil Ishwood, an SME and strategy leader in our third-party risk and compliance line of business. In this briefing, we're going to look at the recent ruling of the EU Court of Justice around public access to ultimate beneficial ownership registers. So firstly, let's just quickly go into the background to some of this. As we know, the fourth EU Money Laundering Directive introduced the requirement for each country to create a UBO register. However, many states made this only accessible to law enforcement authorities, which the financial sector argued made it not very effective. The fifth directive then went further and stipulated that they must be publicly accessible. Although even with this, many countries dragged their feet in terms of creating them, and they weren't necessarily easy to access or even free. Luxembourg was one of the first to introduce one, and it did make it completely free to access. However, a couple of individuals then challenged the Luxembourg business registers, saying that their ownership interests would open them up to disproportionate risks and also infringe their rights to private life. The existing implementation does include exceptions whereby individuals can request their information is not published, which these individuals did, but the business register considered their respective situations did not meet the requirement to do this. The Luxembourg District Court then referred this to the EU Court in the form of two cases that were then subsequently joined together. They asked to consider the nuances of the language around a number of areas relating to risk, disproportionate risk, exceptional circumstances, as well as the respect for private and family life. So onto the ruling itself. The cases do go into quite some detail around the specifics, but essentially it boils down to weighing up the objectives, i.e. combating financial crime and preventing money laundering, versus the interference with Articles 7 and 8 of the EU Charter in respect to the rights to personal and family life and the protection of personal data. We don't have time to dig into all aspects of the arguments in this briefing, but some of the concerns that came out centered around the fact that general public access to this data means that there is no boundary to the original objective, i.e. you could use the data in all sorts of other ways unrelated to combating financial crime. Other areas of the ruling suggest that it is not suitably clear that public access actually advances the objective, something which Transparency International have refuted with their submissions to the court. The court, however, did point out that Articles 7 and 8 are not absolute rights, so they do not simply override everything, but they must be shown that the level of interference is proportionate to the objective. So let's look at some of the reactions to the ruling. Well, proponents of transparency are clearly up in arms about this, with many articles claiming this is going back to the Dark Ages and serious setbacks to the fighting of financial crime. And this sentiment seems to outweigh the other side of opinion that declares this as a victory for privacy, with the law firm that actually brought the case forward and a number of offshore firms seemingly taking this stance. Transparency International submitted an amicus curiae to the court, which outlined that within months of the register being made public, investigative journalists were able to uncover multiple cases covering corruption, conflicts of interest, money laundering, etc., also including additional references to the Panama Papers. Following the papers, which leaked beneficial ownership, more than $1.2 billion has been recouped in 22 countries amongst a number of investigations. Other proponents claim that the court is disconnected from the challenges faced in combating financial crime, including pointing out that the EU's own post-mortems into recent money laundering scandals cited the lack of information available in regards to UBO as a direct factor, and hence the groundswell behind the fifth directive to make it public, and further arguing that the interference with Articles 7 and 8 was baked into the decision in the first place. The impact of the ruling has already been felt, sending shockwaves through the EU, with a swathe of registers being taken offline. As of writing, the Netherlands, Luxembourg, Belgium, Austria, Germany, and Ireland have all closed their websites for their registers. The next steps and permanent future are yet to be clarified. Some have already closed access, whereas others have not. So this may indicate that either some are waiting for instruction from the European Commission, or perhaps waiting for changes to national and EU law, potentially repealing parts of the fifth directive. And one would expect that numerous other bodies would weigh into this argument, including the FATF, OECD, etc., all of whom have specifically cited the need for transparency to achieve their aims of tackling corruption and money laundering. So in summary, a huge blow for transparency and anyone involved in due diligence, whether that be for KYC, KYB, supplier due diligence, etc. And to finish, here is a statement made by the OECD around the importance of beneficial ownership information and how anonymity enables illegal activities. And secondly, a quote that I think is quite pertinent from the UK's recent Corporate Transparency and Register Reform White Paper. And this states that transparency is the price you have to pay for limited liability. So we now need to wait and see what the long-lasting impacts will be, and if a counter case is made in favour of keeping the fifth directive in place in its current form. So thanks for listening, and if you have any questions in these areas, please contact us on the details on screen.